Good evening to all the participants in India and my wishes to other participants across the globe. On behalf of CNICA, I'm privileged to welcome all the participants for today's study series. You have been a wonderful source of support and inspiration for Synicum to conduct the study series. Today's topic to the study series is International Commercial Arbitration, the Effect of Culture. With world becoming a global economy and countries opening up for foreign investments, there has been rising cross-border disputes. In the given scenario, arbitration has become the preferred cross-border dispute mechanism rather than the national courts. Transcending national borders, there has been global rise in arbitration practices. Disputes referred to international arbitration often bring together arbitrators, counsels, and witnesses from different jurisdictions with different culture and practices. Despite increasing harmonization in international arbitration, there remains inevitable differences arising from varied background and environment. In the above background, today's topic to the study series, International Commercial Arbitration, the Effect of Culture, has a very great significance. We have with us today an illustrious and erudite person, Dr. Chandrika Subramaniyam. Dr. Chandrika, with a vast experience in arbitration, would share with us her experience as to what extent the culture would impact international commercial arbitration. Her very presence brings an aura of energy. May I request our chairperson, D. Saravanan, to welcome today's speaker, Dr. Chandrika Subramaniyam.
Thank you, Mr. Anand. Thank you, Mr. Ashok Kapadi. Good evening, friends. Good evening to one and all. On behalf of Seneca, I extend my warm greetings to all the participants. The speaker of today's topic is Dr. Chandrika Subramaniyam from Australia. Dr. Chandrika Subramaniyam hails from Sivagangai, Tamil Nadu in India and graduated in Bachelor of Arts in English Literature, Master's degree in Mass Communication and Master of Philosophy in Communication from University of Madras, in which she received a state recognition for dissertation topic, Position of Women in Tamil Nadu, Media Portrayal. Dr. Chandrika worked as a newspaper journalist and editor in India, and then she migrated to Australia in 1997. She pursued a bachelor degree in law from Western Sydney University in 2006 and obtained a diploma in legal practice, College of Law, Sydney in the same year. Then she secured Masters in Law from Queensland University in 2014, having specialization in dispute resolution and international trade. Dr. Chandrika is a nationally accredited mediator in family dispute resolution and also conducting community mediation sessions. She has vast teaching experience and an advisory member to Justice Department. Dr. Chandrika is currently practicing as Solicitor and Barrister, Supreme Court of New South Wales and High Court of Australia. Dr. Chandrika has many accolades to her credit, such as APJ Abdul Kalam Award for Law Book on Cyber Laws and Cyber Crimes in 2019, Ulaga Tamil Arinyar Award from Government of Tamil Nadu in 2017, Woman of the West, Western Sydney University in 2012, Highly Commended Award, Women Lawyers Association in 2011, nominee for Justice Award, Law and Justice Foundation in 2009. Dr. Chandrika has articulated many research papers on various topics, but not limited to international commercial arbitration and cultural challenges, India becoming an arbitration hub, 2016. WTO and India, Dr. Ambedkar Law University, Chennai, 2014. Dr. Chandrika has published 25 books both in Tamil and English. Chandrika has also recently founded the Support Organization for Migrants Advocacy, which provides a free legal service for women and aims to ensure that they have access to suitable legal advice. At every turn, Chandrika encourages women to become lawyers so that they can work towards a brighter future and give back to their communities as she is doing now. Seneca is really pleased to have her presence in this digital platform. I request Dr. Chandrika Subramaniyam to take the digital dais and address the August gathering. Thank you so much.
Thank you very much. Welcome to the organizers and the members of Seneca. especially Mr. Saravanan, who invited me to address this gathering today, and all the members of legal community around the world who are listening to this, and all the listeners. Thank you very much for your opportunity. Today's topic is going to talk, I'm going to talk about the cultural impact in international arbitration. What I will be doing is, personally, I will be whatever experience I've gained, I'm trying to imply into this. Plus, I will be talking about culture, tradition, and all the other related issues. Then I talk about international arbitration and the researches which is done all over the world about the international arbitration and culture related stuff, the gist of it, and then I will also suggest what is needed to be done in the future. International arbitration has thrived in 6 decades following the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards in 1958. The New York Convention is the cornerstone of international arbitration success, as the New York Convention applies to the recognition and enforcement of foreign arbitral awards and referral by a court arbitration. The positivity of arbitration awards is it has enabled arbitration awards made in any signatory country to be enforced readily in any other signatory country without reconsideration of the merits of the disputes, which is the substantial award thing. International commercial arbitration, the general advantages, and an alternative to national courts, a private mechanism for dispute resolution, selected and controlled by the parties, final and binding determination of parties' rights and obligations. The critical advantage of international arbitration is enforcing national court judgment in other nations is typically subject to a longer and more involved process, and often includes some examination of whether the judgment is rightly granted or not. This is the critical advantage that arbitration holds over proceedings brought in national courts, and sometimes people are satisfied with a third party rather than national courts. However, there are some shortcomings in this process. Failure to achieve cost and time effectiveness, the outcomes, which is the purpose of this process. Failure to satisfy the international trade participants by making it efficient. Sometimes questioning the administration of justice process in the state. The ambiguous nature often ending up in judicial intervention many times in many countries. Enforcement of arbitral awards normally intercepted by public policy of the state in some country like China. The nature of the global businesses is always considering the businesses are dependent on global trade. It becomes vital to understand the culture of people whom our business depend. International arbitration is a global business, so it is vital to understand with whom we are interacting, what we are presenting, what we are gaining. It's like a business model where culture makes a part of it. So international commercial arbitration does not exist in any vacuum. It grows out of needs and opportunities presented by the growth of global trade and commerce, the expansion of financial markets, the rapid increase in telecommunications, the massive expansion in the movement of peoples and businesses throughout the world, and the inadequacies and imperfections of national courts providing redress to them have a legal dispute arising out of a commercial transaction inter-country level. What is culture? I don't know, what is your understanding? Because I always start quoting unity in diversity, which has been a word coined in India. Whenever I talk about culture, that's what I say, that India is the best example for cultural diversity, where we accept and live with other cultures. Culture, according to me, is a cultivation of soul. Whereas Cicero, one of the orator in Roman Empire, says it is a learnt behavior. It means the process of improvement of cultivation of soul. That's what Cicero says, and I believe in that. It's a cultivation of soul, We say, well, you are not cultured, you are uncultured, your behavior is not cultured behavior, means our soul is not cultivated. That's what my understanding. All our Vedic and religious literature also tells us culture is a cultivation of soul. So that's what I believe, as I come from Indian background. What is culture is the way we live, including what we wear, eat, our arts, and even our ancestors. Culture is our identity in terms of our beliefs and behavior. That's what Bobby Kalman in his book, What is Culture, says. I will be quoting all the literature which I have read in relation to arbitration and culture, which will be supporting my presentation today. Culture and perception, it applies to anything that is related to thoughts, values, beliefs, ways of thinking, and perception of the world. Aims of culture. Designed by society in order to live, culture must be flexible and able to adapt to new situations in order to survive. People make sense of the world through their own particular world view. We all see the world with our own eyes, what we perceive, what we understand, and that's how we come to a conclusion about what's happening surrounding us. Culture is a colored glass in that way. If you wear a green colored glass, you will see everything green. This world view is like special colored glass placed in front of people's mind and eyes by their society to see the world in a particular way and color. That's Waring and others in his book he has written. How does the glass work? The glass is painted based on the environment, the geography, the history, the geopolitics, and most importantly, the availability of material and intellectual resources. So just apply this to an arbitration condition and see, you will understand how it works with the arbitrators. What is the difference between culture and custom? Culture is different from custom. You can't disagree with this. Custom, on the other hand, is what people do habitually. It comes as a habit. It is in the distinct way in which people behave in a community as a community, or whole community. Custom in a community are not written by law, but consist of a long-standing and persistent way the people do things. That's what Bederman says. Custom is the physical manifestation of abstract thoughts and beliefs. Custom presents itself in body languages, behavior, dress codes, food, habits, living styles, lifestyles, everything. It is the behavior and action that are repeated through people's lives habitually and are often copied by the next generation who are brought up with a certain custom. What my grandfathers did, I must be doing. My mother and my parents must have been doing. What I picked up from them, then my generation will do. But it also changes when things changes, like we migrate, we pick up certain custom, we believe in certain custom, and we try to adapt to a certain custom. So it is volatile. Part of you, custom is also part of you. It is inseparable. It always works with you. If you continually see a certain behavior and way of living, it becomes so much a part of you that is difficult to comprehend living without these things. Like people get accustomed to the television shows. I think so many channels we have in India. People can't live without watching it. People are very happy in this COVID situation. Okay, we have internet, we have all the television, even the old shows that you are showing, at least we have something in front of us. So the idiot box is the best companion. So that's the customs we have developed over the period. The newspaper culture, if you take, people were addicted to Indian Express, then people were addicted to Hindu. Now, the print culture is going backward, and we may lose all these papers, but most people are used to seeing their news in the mobile phones. So that will become your culture and custom in future. What is tradition? Tradition is different from custom and culture. The transmission of customs or beliefs from generations to generation, or the fact of being passed on this way. That's what the Oxford University Dictionary says. I could not find a better explanation for this. whatever the customs, whatever the culture, whatever the beliefs, whatever the value you have in the past or through your family system, you get it transmitted and you follow the same customs, beliefs, generation by generation, then it becomes a tradition. We call this as a tradition. We say that this is the traditional way we run the wedding. We say it's a Tamil wedding, and suddenly we get all this mehendi and other stuff. Where do we get it from? Is this part of your tradition, custom, or culture? That's how it works. Traditionalists also have a subculture within the culture that may have so many differences. Like if you take one particular community, the Mudaliyas, there are so many Mudaliyas, and there will be a lot of differences in their cultural thing. When they get married also, there are clashes of those things. So there may be a conflict with modernists. The traditional customs or subculture within the culture may conflict with the modernist. And people also change all the time. We'll talk about cultural differences are often classified as associated with their geographical location in the world. For example, culture is identified as Western culture. We talk about European culture. We talk about Eastern culture. We also talk about Middle Eastern culture, African culture, Arabic culture. Again, you take North Indian culture, then you also talk about South Indian culture. Then we say we behave this way in Madurai, Coimbatore as a different thing, Chettinad as a different thing. So this is how the culture is different in place. Even if you take as Tamils in Australia, the Sri Lankan Tamils have a different behavior. Again, among them, they have Trincomalee a different way, Batikalo a different way, Jaffna a different way. And Indians from upcountry, from Colombo, they have different way. Indians from South India has different way. There are Tamils coming from Mumbai and other places, they have different culture. This culture is a lot of differences among themselves. It's volatile, as I said before, and it's not fixed. It changes time to time. We talk about traditional weddings. Do we still follow the traditional clothing for the weddings? No, if in the mehendi, we try to wear the North Indian clothes, and in a reception, we try to wear the Western clothes. So it all takes shapes how you perceive things. People from different parts of the world have different cultures. Culture is not fixed, but rather than it's flexible in order to fit the purpose of survival. That's the bottom line. It fits the purpose of survival. You want to survive, you try to be like others, you want to adapt certain things for you to show that you are among that community. That's how the culture takes shape. Many cultures, people belonging to the same culture have similar basic beliefs, values, and perception of the world around them. Additionally, there are many different layers of branches, same beliefs and values are built on top of these basic beliefs and values, creating subcultures and individualities amongst members of group. Therefore, information about other cultures needs constant updating. Without understanding the other culture, how would you survive in this world? How would you survive in a profession? Say, you being lawyers, you have a North Indian client, you have an Andhra client, you have a Kerala client. If you don't understand their culture, can you survive? I don't think, because I am in a very multicultural state. Like Australia is a multicultural place. You get about 300 odd countries, people living here, 300 communities living here. They all come to me with different things. I can't be the same to everyone because I have to adapt myself to update my constant updating needs to run this business. Example of Eastern culture is is confident and regard themselves as people from an old civilization. We also say we are from Indian civilization. They distinguish themselves from primitive culture. Iranians identify each there by local place of origin in Iran. If you take the Sri Lankan Tamils also, they identify their culture from which part of Sri Lanka they belong, north, east, or in between, or in Colombo, middle, or whatever it is. Culture and communication goes hand in hand. Interpretation of phrase, how did you go? What will be your answer? Some people say, I did very well in my exam. But if you ask a non-English speaking person, how did you go? He said, I came by bus. I went by bus. That was the first thing you do. Like, can you make a duck soup? To you, it's a new word. But if you say in Australia, they'll say, all right, making a cake is like a duck soup. That's that easy. So culture also goes with slangs, communication, and different parts of the world use different kinds of interpretation for certain words and phrases. That's how, if you say that what the Palamoli or whatever we say, the thing, proverbs, the Tamil to an Australian-born child, this is the phrase. They will literally try to fit into the word, and they will not understand it is a proverb. So that's how the culture and communication go hand in hand. So what we have perceived from all these things so far is we understand culture is bundle of values. It interacts with communication. It is a best of the emotions of a person. So three of these make culture to one single person. International arbitration, it is a business. We all agree. It operates as a sub-legal system. It's something closer to legal system, but not a legal system. It involves people with different cultures. It's dealt by people with different values. It is conducted by communication. It involves emotions as part of the culture. If you rethink all these what I have said now, you will understand what I have spoken last 15-20 minutes. So I try to say what is involved in international arbitration in a different aspect to those in cultural part of it. As a business, awareness of cross-cultural issues is the contemporary world of fast travel and fast communication is highly important in general and in business in particular. It is applicable to arbitration too. So awareness of cross-cultural issues is very important. Arbitration itself is a commercial culture, as its own commercial culture. However, international arbitration culture is very different from court culture. We have a different culture in court. It may be India, may it be Australia, or it can be England or any part of the world. It may not be the same court culture, but the court culture is a court culture which has the law and all the other rules and regulations and stuff. The driving force behind arbitration culture is the merit of the case and the specialization in the technical nature of the subject that is being arbitrated. These are the two things we should always remember: merit of the case and technical nature of the subject of the arbitrated matter. Apart from commercial nature, international arbitration also fails legal culture and human culture. We all know legal culture is totally different because we are all lawyers or in the profession of law. The human culture is a socio-economic thing, which we have discussed in my past 15-20 minutes talk about all the differences in human culture. Let me put it in a nutshell. Human culture, the clients from various countries will have latent or patent cultural differences, which may result in differences in forming opinion and action behaviors. Example, a Chinese chairperson sitting in an arbitral procedure, an Indian arbitrator is arguing it, there is an English counsel. Any one of these will not have the same cultural appetite. When I say cultural appetite, one who has a craving for the cultural understanding. However, they are responsible to resolve the cultural conflict, to resolve the conflicting issues. Unless you resolve your cultural conflict among yourself, you're not going to resolve the conflicting issues at all. Legal culture in international arbitration is, as to understand the legal cultural differences, is mainly refers to the clash of legal cultural differences such as national legal culture, because that's the seat of, it's the first place where it is originating, the country where it is, the arbitrary matter is arising, and where it is sorted is international legal culture is applicable. So there itself, there are two types of culture we are saying in legal culture. Legal culture and cultural acceptance. The legal culture is built upon state, society, where it is originated, its fundamental values, its cultural values, its legal needs. All these things make in state society. Difference of one country's cultural values to the other countries modify the attitude, thought process, legal reasoning, the decision making pattern countries. This places a professional responsibility on arbitrators to have a better understanding on cultural differences in order to identify the issues effectively and engage themselves in resolving the disputes appropriately. A research done by World Bank's Research and Development Department, it's a financial sector which did this research, International Institute of Corporate Governance at Yale University, this research was conducted, has thrown light on aspects of legal cultures that may help us to understand better the advantages involved in conduct of an international commercial arbitration. What the report says, that's a 2003 one, there may be a later one done, I am not very sure. The issue of conflicting cultures in international arbitration is a process, and the possibilities of this process, the application of the native laws by Western judges, that is East-West conflict is identified, the recognition of awards despite their annulment in the arbitration seat country, that's a conflict again, divergence between the practice of common law countries, the civil law countries, and the Middle East related to evidence and procedure, again, these are some of the conflicting possibilities. Let us see the major institution in Asia with cultural differences. Mongolian International Court of Arbitration, Japan's Commercial Arbitration Association, China's International Economic and Trade Arbitration Commission, Hong Kong's International Arbitration Center, Korean's Commercial Arbitration Center, Philippines Dispute Resolution Center, Thai Arbitration Institute, Singapore International Arbitration Center, Kuala Lumpur Regional Arbitration Center, which is AIIDR now, Badan Arbitrasi National Indonesia, which is BANI in Indonesia. Among these, we see a lot of cultural difference. Don't we agree on that? Because Malaysia will act differently, Singapore will act differently, Western countries will act differently, Arab countries will act differently. So we'll see some of those. Let us take Arab nations. The mentality, history, and customs of Arab nations play a vital role. Their cultural foundation is based on Islamic faith. The sole source of law determining the jurisdiction in that area is based on constitution of the country and the Holy Quran. Hearings are fundamental procedure and witnesses are in the form of written evidence. So that's a different story. Take China. There are a lot of gaps in arbitration procedures and laws, ambiguous provisions in current legislation, lack of party autonomy, it's a control-freak country, administrative interference in arbitration practice, the government always interfere with any of those procedures which comes up. Let us take Japan and see. Japan with Asian and European culture combination, with combined culture with the international respect achieved in the legal profession, should have attained a position as a leading center for international arbitration. The truth is, arbitration is very rarely used in Japan. Don't ask me why, I don't know the reason. But Japan doesn't use arbitration a lot. Because with all their facilities and their Western influence, their Eastern culture, whatever they have, with all these things, they would have done very well in arbitration, whereas Japan is not used very much in arbitration. You take Indonesia, the cultural differences also come into play in an arbitration proceedings in that country. There's a greater readiness in Indonesia to delegate decision-making to someone else. They try to push things. One would be reluctant to use the Indonesia aggressive approach that someone in Australia may be enthusiastic about adopting. Face saving is important to Indonesian culture, and there is no enthusiasm for wanting to make people look bad. That's the international scenario in Indonesia in relation to international arbitration. But we are very successful in Singapore. Why? Singapore has set a successful model. People prefer Singapore as a seat of arbitration. One of the reasons for this success is to bring into full play of expertise and cross-cultural advantages of the legal and technical experts in different industries in China to resolve cross-border commercial disputes involving Chinese enterprises. The proximity part of it. Let me see what Shanmugam, the minister, in 2011 said about the success of arbitration hub in Singapore. He has quoted 5 items. Supportive legislative framework, International Arbitration Act, IAA, built on model law. So they got a very good supportive framework to promote arbitration. Commercially experienced judiciary, which has developed pro-arbitration jurisprudence. That means they are trained and they have enough education for them to conduct the arbitral process. Singapore's neutral venue, straddling the East and the West, has given it an advantage. They have the Western culture, they also have the Eastern culture. And its geographical connectivity, it is in middle of it where do most trade-related arbitration comes? From China or any manufacturing or exporting countries. So Singapore is located geographically in a very connective place. Government's effort, actively they consult the industry partners. They just don't make any laws just like that. They are engaging all the consulting industry partners for quick response, and always they amend the laws and policies to suit arbitration as one aspect of legal thing. That's the scenario of the particular countries. Now, where they stand in cultural aspects, how does culture affect the international arbitration? Now you understand from my first part of the explanation of culture and arbitration, I have moved to where the world arbitration centers are sitting with culture. What is the impact? Culture and values in international arbitration have an impact on the professional and personal qualities, credentials, experience, and reputation of international arbitrators is arguably about assessing their ethical cultural approach. If they are conducting the arbitration, the arbitrators have their ethical cultural approach and values and predicting how they will exercise their individual discretion. They have a collective cultural approach. They have collective legal cultural approach. They also have individual cultural exposure. They will use that for the discretion in the management and resolution of a dispute. This is a research outcome from Magdalene. Does the culture influence the awards? The answer to this question might seem a bit simple, but it is not simple. Because consider an instance of commercial arbitration between a Chinese company and an Arabic state arising out of a failed oil project in Africa. To do that, let me list out research related to culture and arbitration. Arbitrators operate within framework of legal systems. They can't go out of the legal system. It has to be framed within the legal system, what's meant for them. Lawyers, judges, and arbitrators operate within the framework of the legal system, and their reality is what they interpret from the law. So that's one of the other research which says. Sweat and Coles are 2 researchers. What they have found out is one must take account not only of legislative rules, judicial decision, the law in the book, and also of general conditions of business, the customs and practices, but in fact of everything whatever which helps to mold human conduct in the situation under consideration. Sweat and Coles are under the impression that everything has to be considered in and around the matter for discussion. And that's how the human conduct is assessed when a given situation under consideration is in the process. Formation of legal concept, according to Bhatia and others, is variation in the formation of legal concept is normative text are mainly to be attributed to the different cultural traits and legal traditions of the communities for which are meant. So that means he believes the formation of legal concepts is based on the attributes of different cultural traits and legal traditions. Accepting culture is very important. I may have a different culture, you may have a different culture. When we sit for an arbitration thing, we also think in terms that all of us should be in the same page. How does it happen? So the important that parties involved be aware of the respective to the difference in approach. You should understand what are the other arbitrators are thinking, what's their cultural background, also the parties involved, also the countries involved, as the participant will bring along with understanding attached to their cultural and professional background, which in turn influence the procedure. That means unless you understand, you have a cultural aptitude and you have an accepting nature of culture, if you don't understand what the other person is thinking, why he is thinking, how he will be thinking, what will be the outcome, and also understand the parties involved, the countries involved, their business culture, and all those things. So this is very important. Take a case, Chinese case, case 1. Assume that all 3 arbitrators are from Europe, that is from a civil law legal tradition. They are experienced arbitrators of the highest integrity and reputation with no conflict of interest. That's fine. Now, the only thing is they are from European background, which is a civil law traditional country. And the law and witnesses applicable to Chinese law, and all the witnesses are either speakers of Mandarin or Yoruba or whatever it is. The Chinese, Cantonese or whatever it is. So the witnesses are going to carry their values, their system, their customs, and their culture. Whereas the European arbitrators are going to carry their values and their beliefs and their legal system. Now think about case 2, a dispute between an Arabian business and a European state. The arbitrators are all from Africa with equivalent qualification as the European arbitrators, but who do not speak a word of Arabic or any European language. What will be their communication then? What should concern the reasonable neutral observer in each of these scenarios? I've given you 2 scenarios. What will be the concern? It shows the same set of facts could be attributed different meaning because of the fact finder's cultural background. Fact finding is the important first step in arbitration. And if your cultural background is different from the arbitrating matter wherever it arises and their culture, what will be the position? And the counsel may be from a different country with different background. There are many concerns. Example of the lack of cultural proximity between the decision makers and the parties who must suffer the consequences of inevitable cultural incommensurability. That is what is not common. But there is one word that could capture them all, that is without fear, favor, or irony. If you apply culture, the word, understanding, aptitude, sensitivity, acceptance, if you do that with culture, all of you will be in the same page. The extreme position would argue that judges are unable to adequately conceptualize the thought and practice and associated material of the members of different culture. Another may suggest that you will never understand our people unless you understand our language. That's why we tell in India also, if you want to bring in Hindi, we don't want that, because if you don't understand my language, you won't understand my sabari. So it's easy as that. So the language space a cultural issue. Unfamiliar culture. When arbitrators are asked to determine facts that grow out of interactions with unfamiliar culture, Miller, on the basis of evidence offered by cultural others, I call them cultural others because they are different from my culture. They appreciate the limitation of the comprehension. Unless you comprehend that I have limitations in understanding your culture, let me take some time and understand that before I come to some conclusion. What do arbitrators do in that scenario? In examining and weighing of the relevant facts, if they have some inaccurate attributions, often lead to erroneous finding. That means if they are not competent to culturally competent to understand what's going on around, surrounding the issue, they may lead to erroneous findings. Erroneous arbitral fact finding is very difficult and dangerous because they're very difficult to correct or set aside for the second time. If not, I will say it's experience with Indian divorce crime. I always have issues with making the Australian judges or the magistrate to understand how Indian culture works, because there's no provision for dowry, there's no provision for alimony. There are deserted women who come and cry in my office. When I try to say that something has to be done, nobody listens because it's not in their law books. But we have something called culture, which we're fighting hard with something else like dowry debts and other stuff. We are trying to include this cultural thing, and we are trying to make white papers in order to put this in order. And the other thing, what happens, the Indian brides, when they get married there, the husbands come here, she comes after 3 months, the same day they just kick them out on the road. The immigration department always say, they never lived together, so they're not husband and wife. So she came to live together, but he was kicked out on the same day. And the argument is, I'm going by the law book. But they don't understand. And when we say that 500,000 rupees given to the mother-in-law, and there are 100,000 sitting in joint account bank, the girl wants to get it, they don't understand, because that's how the cultural thing differs from the judge's mind and the client's mind. And an English case called Balraj and Balraj in the English court, the judge has given an opinion pertinent to this topic. For a judge to try to achieve the insight necessary to grasp the prospect of the lady in outskirts of Hyderabad and the prospects of the daughter of the family living with the mother in Hyderabad calls for the exercise of perhaps greater insight than any English judge should be required to exercise. So that judge is emphasizing that we need some exercise, the cultural exercise I was talking before you come and give this verdict for this, in relation to this decision on this. In the US, jury determination, Doak Bishop and James Carter in one of the book they have written, Perspective and Practice of Advocacy, said, the most important determinant of how a jury decides a case in the juror is the juror's own values, attitudes, and beliefs. That means juror forms his own values, attitudes, and beliefs, how he decides the case. So that's from the United States case. What if the composition of the members of the tribunal is mixed? In case, if the composition of the members of the tribunal, you have 3 arbitration panel members, one from Africa, one from China, one from India, the case is from Chinese background, would the ability of the tribunal to determine the fact correctly improve? It's a question. Say, for example, a Chinese, a European, and African arbitrator in both tribunals, assuming all the other qualifications are equal, but still they have some issues. Research indicates that when jurors of different ethnic groups deliberate together, they are better able to overcome their individual biases. Why is that, you think? When we have 3 different people, 3 different values, 3 different attitudes, 3 different cultural background, but still we are able to come to some conclusion, overcoming the individual biases, because there will be discussions going on. You express and you explain, and before you come to a conclusion, all these arguments will be assessed and you come out with some better outcomes. The broad representative character of the jury should be maintained, partly as assurance of diffused impartiality. That's a book which talks about juries, the jury system, and the ideal democracy. One of the study by Jeffrey Abrahamson, he says that the broad representative character of the jury should be maintained, partly as assurance of a diffused impartiality. How do you diffuse the impartiality? This is, you have some cultural aptitude and cultural attitude. In addition, Western world's answer to commercial disputes are in questions. Arbitration centers that have hung out There are shingles in many developing countries are also in question. The consensus really only reflects the imposition of Western values. That's what De Silva and Magdalene quote in Mason and Smith. De Silva and Magdalene say, the consensus really only reflects the imposition of Western, and that means Western arbitrators, they have Western values, showing ignorance of cultural differences. So they try to emphasize the cultural differences cannot be ignored. People have to understand, you have to educate yourself, the consensus really reflecting the Western values. So that's what De Silva says. One of the strengths of arbitration is international arbitration accommodate 3 persons in a tribunal, which is good. It's not 2 people. So 3 people, it can be of your choice sometimes. At least one member of the tribunal having nominated by a party from who has experience of and is culturally sensitive to the nuances of how business is done and communication undertaken in that country. So when you have that choice, that person can be from your own country, where he has a background of the cultural part of it and all the communication. Communication differ from places to place. Communication differ, even the body language, or it can be in a verbal or non-verbal. It has different meaning in different countries. So we have the facility on this. One of the strengths in the international arbitration is we can have one party or one arbitrator who understand the culture and communication. Let me put together what are the challenges we see in international commercial arbitration. Cultural bias and stereotyping. So when some of them come and sit, they always are, he's an African, they will behave like, oh, he's a Chinese, he's going to do this. So stereotyping is there. And the politics and religion plays a predominant role. If you go to an Indonesian court or to an Arabic country, the Islamic faith predominantly dominate the arbitration process. Miscommunication, it can be verbal and non-verbal, as I said. Cultural precepts of negotiation. When you negotiate, the perceptions also are different. So these are some of the items which always face challenges in international commercial arbitration. The misunderstanding is a big question. There are still many parties and lawyers who do not fit into the global mode. We all think we studied law, we got masters in law, PhDs, we are practicing, we have practiced for 10 years, we are the best lawyers, we can go and work out things in Western world. I every day see people who studied in India coming and doing the bridging course to become lawyers with no clue how the court works. They think the courtroom is like in Gauravam Sivaji Ganeshan's court, where you can argue with, hit the table and you can argue the way you want to argue, shout and scream and stuff. It is a simple process. You just sit or stand and address the magistrate and you tell your cases in a very subtle way. Plus, there are procedures totally different from India. So most of them, they are unable to practice in courts because they don't understand the court procedures at all. So this is to get into a global mold, we have to prepare ourselves. We have quoted many examples of cultural misunderstanding between developed countries and Western economies and other jurisdictions, between civil law and common law. Again, civil law and common law countries have different cultural aspects. Cultural differences in international arbitration conference was held in Berlin in September 2014. It's done by Humboldt University, devoted entirely to legal differences. The conference had discussions of important issues regarding the interpretation of different laws. An example of cultural diversity was the understanding of the disclosure of documents. However, there was no mention of social cultural differences. They talked about cultural diversity, but there was nothing mentioned about social cultural differences. In response to claims regarding the differences being silent on social cultural differences, lawyers dismissed the role of non-legal culture factors having any role in international dispute resolution. That means they did not accept it, whether non-legal cultural factors having any role in international dispute resolution. After hearing, it's about 40-50 minutes I would have spoken to you, Do you think that the cultural factors do not have any role in international dispute resolution? I don't think so. I will strongly believe culture has a role. Ian Meredith and Henrik Puschmann suggest communication with cultural understanding influence the following areas of arbitration process. An expert witness faltering under cross-examination, coaching the witness, a tribunal relying on documentary evidence to the exclusion of witness testimony, fact witnesses under cross-examination, document production, supporting the document, the reasoning of arbitration awards, cultural misunderstanding. All these things come under misunderstanding, cultural understanding, need for cultural understanding. The background of all the participants, in particular in terms of their home legal culture and how it may influence their expectation of the proceedings, is also very important. Unless you understand your home culture, the home legal culture, you cannot train them what is expected in a proceedings and what they have to say without breaking the rule of truth. Common understanding by all parties is necessary to understand culture as a factor in the process, minimize cultural ignorance, and to increase cultural awareness and cultural competence. This all will happen if you can engage yourself with pre-arbitration conferences where if you have any nitty-gritty bit, always you can fix those things. Cultural sensitivity. While risk goes to international arbitration, most businesses and legal culture of new adherent, international arbitration practitioners, both counsel and arbitrators, in turn need cultural sensitivity. Unless you have cultural sensitivity, you will not understand the culture of your parties. This is in part because arbitrators should be attuned to the different ways in which witness speaks when asked questions. Consider communication, education and training program, understanding power difference and cultural imbalances, flexible procedures available in relation to culture. I think I have justified my topic today. Thank you very much for patiently sitting and listening to me. Once again, I thank the organization, Mr. Saravanan and his partners who have invited me today to talk about this. Now I'm ready to take your questions. Thank you very much.
Thank you, Madam. Anybody having any questions may raise it, or they can post it in the chat box. We have some statements, I would say, not questions as it is, which have come up. I will read it out, Madam. I guess the question is whether culture should play a part in arbitrators' award. I think the question is whether culture should play a part in the award, international award.
No, when you start doing the awards, the arbitrator should have a cultural background, a cultural understanding, cultural sensitivity, and cultural aptitude for them before they write the awards. When they write the award, they should bear all these things in their mind so that they do a fair job.
Okay. Mrs. Mandadi has said, naturally, culture influences understanding the issues and relative importance given to issues on hand. I think one way to overcome cultural barriers and in giving due importance to culture issues may be multiple member arbitration tribunal so that the arbitrator chosen by party may protect his interest. That's a statement.
Yes.
And yes,
I agree with that, because that's what we said. We have 3 parties, because even if you have 10 parties, it's going to be more cultural clashes. So it's better to stick to what's been given to us for 3 party. Yeah, that's good. Yeah.
Yes.
I agree totally.
Yes, Madam. One Mr. Akande has said it is a fantastic session, very detailed. Mr. Vaidyanathan has said, excellent session, madam. Thank you very much. And again, Mr. Mandadi has said, wonderful navigation of various facets of culture. Can Mr. Mohit has got a question? Can a dispute
Yeah.
in America get a fair arbitration in China?
America get a fair arbitration?
In China.
And post-COVID or pre-COVID?
And also post-COVID, whether it's going to be in China or in US.
Yeah. See, again, arbitration goes, the seat can be China, but the arbitrators will be at least 3 different people. They all won't be Chinese. So we expect a fair go.
Yeah. Mr. Vinod Kumar has got something for you. Pardon me for addressing you as Chandrika Didi.
Please call me Chandrika, that's what I prefer.
And within brackets, Devi, and again within brackets, Amma. As you mentioned about culture in arbitration, my question is, if having Ganesha image background and wearing rings in the fingers and sporting tilak on the forehead influences people, influences the meeting and hearing, thereby affecting the prospects of party. Thanks.
So that's a cultural thing, you know. Sometimes some people are very discriminative. So when they see an Indian background, some people are nasty. Sometimes it affects.
Yeah.
But see, to be very frank, I walk into the parliament with sari. I don't care what others think. That's my identity, and why should I lose it?
Yeah. Mr. Marius Pot has got a question. He has raised his hand. I will unmute him so that he can ask you the question.
Yeah, thank you.
Mr. Maria, you can unmute yourself now.
Audible?
Yeah, you are audible. Please.
Ma'am, actually, I have a doubt.
Yeah.
Especially if with regard to culture, there are 2 sets of culture, right? One is basic, like handshake or even namaste, that good morning, those things. Another one, deep culture. Which culture we should adopt as an arbitrator or as a counsel? Because at times it affects.
Yeah. So that's what we are trying to argue. There are 3 different cultures. We're talking about the country's culture. We are talking about arbitrators' culture. We are also talking about each country's legal culture and human culture. We also talk about the arbitration culture. We also talk about the witness culture, the participant's culture. The participant may be from 3 different things. That's why I call it an aptitude or appetite to understand all different cultures where you come to a fair go.
Ma'am, because why I asked this question, because especially in Western countries, they always only think about surface culture, whereas like countries like India and some developing countries, they are more sentimental. So for that, some people are suggesting that no, you should know at least some deep culture of that people so that you are able to carry out your process. So that's why I would like to
understand, if it is a law, you can't break it. It's a country's law, you have to stick. This is arbitration. The model laws are based, and those laws are practicable in each country, however you are based in. So when you go to an arbitration table, those laws speak. And if the arbitrators have a cultural sensitivity, and if they can understand what they are trying to say, how they have worked out things, and why they have worked out things, they will be able to come for better understanding, and they can provide a better solution. That's what I have been telling from the beginning, how it works. First, I talked about the first portion, what is culture, tradition, and all those stuff. Then I started talking about each country, how they have done. And then I started talking about what is lacking and what needs to be done.
Ma'am, in this regard, because especially Islamic arbitration, right, which we are hearing about, but there is not that much literature is available. Why it is a kind of cultural restriction kind of thing, or what is the reason behind that, ma'am?
Can I rephrase the question, please?
Yes, ma'am.
You're trying to say Islamic thing, there's not much literature.
Yeah, Islamic arbitration.
Yeah. Yes, what's the next point?
Ma'am, actually, why that Islamic arbitration is not that much debated? When we are talking about international commercial arbitration, we are talking about common law and civil law. model law and unmodel law, but we are not focusing on
I
Islamic
mentioned it
arbitration per
about the
se.
Arabic thing. It's
Arabic.
the Constitution and Quran. Okay.
Yes.
Do you have the guts to go to the street in Madras and say Islamic arbitration is a filthy one?
But
it's very sensitive. Culture is very sensitive. So
yes.
In that country, they are practicing it. You can't do anything. Now, if you do anything here, you will make a big noise. But if something is done in Qatar or Kuwait or Dubai, are we going to talk anything about it? We just see that and keep quiet because that's all we can do.
Okay, madam. Next
thank
question.
You, thank you.
Yeah, thank you, sir.
Thank you.
Next, Mosam Sharma has got a question. I've unmuted, madam. You can ask your question, Mr. Mosam Sharma.
Yes, please. Thank you.
Yes, thank you, ma'am, for this session. It was wonderful. And ma'am, my question is that whether if we consider on the point of culture, then is it easier to go for mediation rather than arbitration?
See, mediation and arbitration are two different things. Why? Anyone can answer that? Mediation, a neutral person comes, try to mediate and get the best out of both parties, and it's a win-win solution. Arbitration is, there are set of rules at international levels, the model rules, UNITRAL or the New York Convention, and you try to set things according to those, but understand the fact-finding. As I said repeatedly in 3 or 4 places, it's not the fact, it's not the process, it is finding the fact in a better way with cultural understanding. So arbitration and mediation are two different things. Mediation will not work for the commercial arbitration stuff. Mediation is good for internal stuff.
Madam, there's a question from Mr. Murali Dharman.
Yeah.
Okay, it's not a question. I think it's an appreciation for your talk. And simple.
Thank you very much.
Culture is the rubrication for Excellent Arbitration Award. So, Lata Prasad has got something to say. Understanding cultural background makes all difference to the arbitration, is what we learned from Madam's talk and on the subject. Thank you for the clarity. Yes, I think
Thank you
that's
very much.
the questions that we have. Anyone else has any questions? They may raise your hand. I think.
Yeah, please feel free to ask. There's nothing wrong. Even if I don't know, I'll say very simply, I don't know.
Yeah, there's one question.
So the one thing I want to point out, somebody asked a question.
Yes, ma'am.
In one sentence, he had 5 items. That's a cultural thing. Most of the Indian clients we get, if I asked, when did you come to Australia? I won't get a simple answer, July 30th, 2019. They will say, in 2015, I was in Singapore. Then I got married in 2017, and 2018, I was working with Wipro. So, and also when they ask question, they bundle it and ask. That's the way we were brought up and we learned. This is a learning process. It's a cultural thing. But if you go and talk to an Australian that way, they will not understand. This is talk. Can you tell one point in one sentence? So that's a cultural thing.
Yes, I understand. We are always used to giving an elaborate answers for everything.
Yes. No. We are brought up that way. The comprehending part and the answer. But on the same line, I have to tell. If we go to Tinelveli or somewhere, you ask for a place, they'll say go right, turn right, left, turn right, and then there's a well and there's a shop and there just turn right. We will understand that very quickly. Yeah. But if you get a foreigner to come and ask that question and get the same answer, they won't be able to go.
Saranand has got a question for you. In mediation, understanding of culture aspects would be an advantage to bring the parties to arrive at certain terms, whereas arbitration is to decide the dispute based on merits. Going by certain culture of the particular party, will it not lead to an attitude of bias?
Sometimes it is biased, but unfortunately arbitration happens only with cross-country issues. We have to understand that. Somebody from Africa is selling gold to, say, to US, and the the company which is buying is in UK, and the ship goes and it meets with an accident in Arabic Sea or somewhere, a different place. And it's a very difficult process where do you conduct the process and how do you conduct the process? And the witnesses are in somewhere in between Africa and US, some country. So what will you do in that scenario? So arbitration, sometimes it is biased. I don't disagree with that. But to overcoming that is the success of that process.
Mr. Mohit has got a question. In case if an award is not in favor in an alien country, what is the last recourse? I think that's going beyond the scope of the topic, Madam Hemshi.
I think beyond the scope, but whatever it is, you see, go and read the UNICTRAL. UNICTRAL is online, and also the New York Convention. You find everything what you ask, the questions and answers are there. That's the best place to update your knowledge.
Madam, I need to say that we have got a response from Justice Vimala, retired judge of our High Court.
Oh,
he has said,
thank you.
Interesting, impressive, and informative presentation and meaningful interaction. Thank you,
Thank
madam.
you very much for that. I'm really obliged.
I think we are finished with all the questions.
Yeah.
Madam, at the initiation of this topic, I had my own doubts. How does culture come in place with arbitration? You have brought out that very well. And now I understand that culture need not be the influence to pass an award, but it is to understand what the people are and what type of people we are going to meet in an arbitration and understand the dispute as it is. So that clarity we got today from your excellent speech and narration.
Thank you very much. Thank you. I must thank Saravanan because he said the same thing in Malaysia, saying that I didn't think that there's a cultural aspect for it. But he remembered me to invite me to talk to you. And it's a nice meeting because I was thinking of when I come next time I should meet some of you. But thank you for Saravanan to make this opportunity for me.
Thank you so much, madam. Thank you.
Thank you, one and all. And I also thank all the participants for being present here. And the announcement is with regard to the next webinar that we are going to have. It will be on 5th June 2020, that is next Friday. It will be on third-party funding international commercial arbitration by Jern A. Filling QC, Barrister Excess Court, Chambers, London. He is well known in this particular law, and we expect him to give a very interesting speech. The speech will be at 6:30 p.m. IST. Thank you.
Thank you. I have a question.
Yes.
Did you record this?
Yeah, we recorded it, madam. In between, I think there was a slight snag, but anyway, I'll attach it and it will be uploaded in the YouTube.
Okay, thank you very much for that.
It is also live on the Facebook also.
Okay, thank you very much. Thanks for that.
Thank you.
Okay.
Bye.
Thank you so much, madam.
Thank you. Thank you.
Thank
We'll
you.
catch up later.
Yeah,
Thank
sure,
you,
madam.
everyone.
Thank you.
Thank you.
Thank you, everyone. Thank you.